Good afternoon, everyone. I'm Tony Varona, Dean of Seattle University School of Law, and it's my pleasure to welcome you to the Dean's Luminaries in Law Lecture and Conversation Series event today, and our podcast episode as well. This is the fourth year of our Luminaries in Law series. We've been honored to host an array of legal luminaries and leaders serving justice from all sectors of law and policy, including the courts, industry, law firms, government, journalism, and the academy. Today, we host a luminary in law who is a dear friend of Seattle University School of Law, Professor Ilya Somin. Professor Somin is professor of law at George Mason University and the B. Kenneth Simon Chair in Constitutional Studies at the Cato Institute. He is the author of many celebrated books and has published in top law reviews, including the Yale Law Journal, Stanford Law Review, Northwestern University Law Review, and the Georgetown Law Journal. Professor Somin also is a frequent expert commentator in national and international media on a range of important subjects. He holds a BA summa cum laude from Amherst College, an MA in political science from Harvard, and a JD from Yale. The topic of today's conversation with Professor Somin is how immigration is not invasion. And the conversation will be conducted by my distinguished Seattle U Law colleague, Professor Andrew Siegel, who also serves as the faculty director for our project on the Supreme Court and our constitutional future. Andy will engage Professor Somin in conversation through about 12:40, and then we will have about 10 minutes for questions. I will lead us in the Q&A session. If the many of you in the room with us today have questions during the conversation, please email them to luminaries@seattleu.edu. luminaries@seattleu.edu. They'll go right to my iPhone, and then we could work your questions into the Q&A session. So with that, Andy, please take it away.
Thank you, Dean Varona. I really appreciate that. I really appreciate the opportunity to engage in that conversation. Really welcome Ilya to our building and to this series. I have a lot of interesting questions to ask Ilya. He's had an interesting career, and maybe we'll get to some of the other things he's worked on. But we're going to start on the topic today, which is a fascinating and thorough paper that he's written on the subject, making the argument that immigration, even massive illegal or undocumented immigration, does not count as invasion for constitutional and statutory purposes. I'm going to ask some specific questions as we go, but to make sure we're all on the same page, I'd love for Ilya to start us off by giving us kind of a short summary of the arguments here, in particular focusing on two things. First, how did this issue arise? Why do we need this paper? And then what are your arguments for your conclusion?
Sure. So the issue of the definition of invasion after somewhat of a hiatus has been made great again by recent events. The word invasion, or a derivative thereof, occurs 4 times in the Constitution, and it also occurs in the Alien Enemies Act of 1798, which allows detention and deportation even of legal migrants in a situation where there's, quote, an invasion or declared war or a predatory incursion to the United States. A couple years ago, the state of Texas argued that illegal migration and drug smuggling qualify as invasion, and therefore they could do various things that otherwise would be illegal under federal immigration law, because the Constitution says that when states are actually invaded, they can, quote, engage in war in response. And Texas said, well, if we can engage in war, we can certainly do somewhat lesser things, such as place buoys in the Rio Grande River that might otherwise be illegal, and take some other sorts of steps as well. Then when Trump 2 came in for his second term in office, he issued an invasion executive order claiming that illegal migration and drug smuggling across the southern border qualify as invasion, and therefore claiming that he had the right to block virtually all legal migration pathways for people crossing the southern border. He also invoked the Alien Enemies Act of 1798 in response to the activities of the Venezuelan drug gang Tren de Aragua, and the result of which several hundred Venezuelan migrants were detained and sent to horrific imprisonment in El Salvador, even though in most cases there was little or no evidence that they actually were members of any drug gang. And the claim here is that Tren de Aragua, because they're involved in drug smuggling, illegal migration, was invading the United States. Previously, the Alien Enemies Act had only been used in three major wars: the War of 1812, World War I, and World War II. So because of these developments, I felt that we were due for an article that comprehensively examines the meaning of invasion, both in the Constitution and in the Alien Enemies Act, because a lot turns on this and because these issues are being litigated in the federal courts, several of them even as we speak, and also because there are large stakes here. So the word invasion occurs in the Constitution in 4 different places. In the suspension clause, which says that the writ of habeas corpus can be suspended, among other things, when there is an invasion, and therefore people can be detained without any due process, including U.S. citizens. In the guarantee clause, which says that the federal government guarantees the states against invasion. This is what Trump is using to justify his invasion executive order. It also occurs in the invasion clause, also known as the state war clause, which says that normally states cannot engage in war without authorization by Congress, but they can do so if they're, quote, actually invaded. And then finally, in the calling forth clause, which says that the federal government can federalize the state militia and use them for federal law enforcement purposes when, among other things, there's an invasion. So with the help of my long-suffering research assistant, we went through and cataloged every single reference to invasion at the Constitutional Convention, at the state ratifying conventions, and in the Federalist Papers, and we found that every single one which refers to the actual invasion clause of the Constitution refers to invasion as a form of military attack on a significant scale rather than illegal migration, drug smuggling, or other similar phenomena. There are many, many examples we can talk about the details of. There are lots of metaphorical references to invasion in these sources, such as cases where people refer to the invasion of the powers of one branch of government by another, just as we today use metaphorical references to invasion in our everyday speech, like invasion of privacy. But none of those metaphorical references have anything to do with the invasion provisions of the Constitution. And if they did have something to do with them, if any time there's illegal migration or smuggling or like that's an invasion, and you could suspend a writ of habeas corpus, you would expect people to have raised that issue and complained about it. And they did not, and that is a very significant point. I did the same thing with the discussions about the Alien Enemies Act of 1798, and there is the same story there. It is significant that the Alien Enemies Act was paired with the so-called Alien Friends Act, which really did give the president the power to deport any non-citizen that he considered to be dangerous in some way. People like James Madison and Thomas Jefferson, many others, vehemently argued against the Alien Friends Act on the grounds that it was unconstitutional, which I think, by the way, they were right about. They did not raise similar objections to the Alien Enemies Act because it was understood to be limited to actual cases of war or invasion. So from an originalist point of view, there is overwhelming evidence in all of this that invasion means, as James Madison put it, an operation of war, not illegal migration or drug smuggling or something metaphorical, but the administration has taken the opposite position, and they have even said that the president deserves total deference with respect to when he declares that an invasion has occurred, so much so that in recent oral arguments before the en banc Fifth Circuit, Chief Judge Elrod asked the Justice Department lawyer whether the president could invoke the Alien Enemies Act in response to the British invasion of rock stars like the Beatles. And the administration's lawyer said, yes, the courts would have to defer to that. This is actually one of the metaphorical use of invasion I referred to in an earlier draft of my article. And it played out in real life. In the latter part of the article, I explain why there should not be deference to the federal government, the administration, or the state governments when they claim an invasion exists. Courts should not defer either on the textual issue of the meaning of the word invasion or on the factual issue of whether an invasion is actually going on. I have a long list of reasons why there should not be such deference, but the biggest is simply that if there is, either on the legal point or on the factual issue, then powers that are only supposed to be used in extreme emergency situations, like when there is an actual invasion, for example, would become blank checks that the executive or state governments could use at any time they want. This violates originalism and textualism. In a part of the article, I also explain why it goes against various leading versions of living constitutionalism, and it would have very dangerous practical consequences. For example, we virtually always have illegal migration and drug smuggling. That means the writ of habeas corpus can be suspended at pretty much any time. They could detain people without trial. There are other dire consequences that would follow as well, which I go over in the article. So much more can be said, but I think that's at least a basic overview to start with.
So I had the same reaction listening to you today as I did when I read the article. I've rarely seen a legal question that is the subject of a long law review article where the answer is more clear, where all the modalities of interpretation point in the same direction. So I'm going to kind of ask you a meta question. For people who don't know, in addition to Texas making the arguments and the Trump administration making the arguments, I think exactly two federal circuit court judges have written opinions, at least on the same or related questions, suggesting that there's something to the invasion argument. How do we get to the point where this is a debated legal issue? Did something break down in our politics or our law that we have federal appeals court judges reaching what seems to be a clearly erroneous alternative conclusion, and the administration making arguments like the British invasion argument in court? Like, how did we get here?
Yeah, so there's both a historical reason and a more immediate reason relating to our politics now. The historical reason is there is indeed a long history of analogizing immigration of various kinds to invasion, which goes all the way back to the 19th century. You see it in the hysteria about Chinese and other Asian immigration at that time, and you see it at some later periods as well. Also, was actually a previous round of invasion-based litigation in the 1990s when various states, including not even really red states like California and New Jersey, said illegal migration is invasion, and they argued that therefore under the guarantee clause, which I mentioned earlier, the federal government has an obligation to protect them against it, and if not, to at least compensate them for expenses that arise from illegal migrants that come into their borders. And at that time, various federal courts ruled either that this was a political question, but also when they reached the issue, they ruled that an invasion has to be a military attack. So there is that long-standing history, but obviously there's also an immediate history that over the last decade, our politics, like that of some other countries in the Western world, has shifted to the point where sort of right-wing nationalist nativism is a bigger force in our politics than before. Attacking immigration and immigrants is a major part of the agenda of one of our two dominant political parties, and they search for sort of every legal argument they can get to try to enable them to take drastic measures without having to pass new legislation through Congress. And this is one of the sort of arguments that they came up with. It was available from before. I'm not sure exactly what it is that turned them on to them, whether they saw the litigation from the 1990s and looked at those cases, or whether they came up with it in some other way, but they did hit upon this argument. First, Texas did under the Biden administration, and then later, obviously, the second Trump administration as well.
You talk about kind of the underlying hostility to immigration that motivates all of this, and certainly we have an American tradition of that. You've written from a variety of perspectives about migration and immigration and things like that. Was that part of the inspiration for this article?
Yeah. So obviously, speaking for me, sort of this article is a combination of two of my research interests. One is the research interest in immigration and freedom of movement generally, which I've been writing about for many years, and I'm a longtime advocate of maximizing freedom of movement as much as possible. I've argued in various publications, such as my book, Free to Move, that virtually all legal barriers to both domestic and international freedom of movement should be eliminated because they're unjust, they're harmful, they're dangerous, they're based on flawed political theories and empirical assumptions and so on. The other interest that is more recent is an interest in the use of emergency powers. And we saw in recent years under administrations of both parties that there is a tendency to try to invoke emergency powers as a pretextual way to achieve sort of policy objectives that the president cannot achieve otherwise. I'm sorry to say we saw this with Biden and student loans, which I also criticized, by the way, even though it's maybe not a great idea to say so in front of an audience of students, but that was, I think, an attempted abuse of emergency powers, though at least there was a genuine emergency, the COVID pandemic. And so this article builds in part on that set of interests as well. I've also written and been involved in the tariff litigation, where I was one of the lawyers in the case currently, or not currently, but just decided by the Supreme Court, which also involves an abuse of emergency powers. So I think this is a problem in the area of immigration, but it also occurs elsewhere. And so this article is the conjunction of those two interests.
You've opened up so many doors. Since you mentioned tariffs, I was going to get to it later, but I know that that's been another one of the major projects you've been working on for a while. Could you, in answering this question, balance the following two things? Could you tell us a little bit about your involvement in that case, both in terms of kind of what kind of your intellectual contribution was like, but also just kind of what it was like organizing with other people in real time to challenge such a major governmental policy?
Yeah. So basically, I'm an academic. I'm not really a professional litigator. In many ways, this is only the second case that I've ever really litigated, as opposed to written amicus briefs or commented on. And so it happened a little bit deliberately, but a little bit by happenstance. When the first IEEPA tariffs were announced in February of last year, I wrote a blog post saying people should challenge this based on A, major questions doctrine, B, non-delegation doctrine. Also noted, as some other people had before me, that maybe the statute just doesn't authorize tariffs at all. And my intent was hopefully that somebody else would read it and they would bring the case, and I would be able to sit back and watch, and pull out the popcorn and maybe write an amicus brief or something like that. But I got contacted by Jeff Schwab, who is the senior litigator for the Liberty Justice Center, a public interest law firm, and he emailed me and said, well, we're interested in potentially bringing this case. But at that moment, we weren't yet sure whether these tariffs were going to stay in place or not. It turned out they did, and in April of last year, Trump vastly expanded them with the so-called Liberation Day tariffs, which imposed tariffs on 10% tariffs on virtually every nation in the world, and so-called reciprocal tariffs on another 50 or 60 countries, many of which there was no actual reciprocity because they applied even to countries like Switzerland and Israel that imposed no tariffs whatsoever on U.S. imports into their markets. And so once that happened, the Liberty Justice Center and I agreed that we would bring the case. And also I wrote a follow-up blog post seeking to recruit clients. And that is how we got some of the businesses that became our clients, like VOS Selections, a wine importer owned by Victor Schwartz. It turned out that one of Victor's nephew is a former student of mine. He saw my blog post. He knew that his uncle was really unhappy about the tariffs, so he contacted Victor, and Victor contacted me. And after a process of vetting, we got our clients. We filed the case. We won in the Court of International Trade, eventually in the Federal Circuit, and eventually in the Supreme Court, that we were over time joined by additional people, including prominent Supreme Court litigators Michael McConnell and Neil Katyal. But initially, it was just me and 4 or 5 people from Liberty Justice Center that were working on it. So it was quite an experience to go from not really doing litigation at all to you're litigating this case that's in the media, that's is moving forward rapidly by judicial standards, though businesses would often tell me, why aren't you going faster? I'm losing money every day. My business might go under. And I would say, this is fast by judicial standards. And they would be that's no consolation to me, right? It's still slow as far as I can tell. But obviously, it was almost like having a second job. It was quite an experience, even though I have other previous experience with media and commenting and writing briefs and so forth, but actually litigating a case, really almost any case, but certainly not one of this magnitude. That was something I had not done before. So it was sort of quite an experience to go from the start of the case all the way up through the Supreme Court, and all within less than a year, which, as I said before, is a fast pace for this kind of litigation, even though I totally get that it's a slow pace for all of the people in the real world who are paying higher prices, seeing their businesses go under and so on.
And are you involved with the remedial portion of the case, or is that now exceeded your expertise?
So it does exceed my expertise, and I made arrangements that I would leave the case after the Supreme Court decision, so I'm not on it anymore. I have continued to write about the tariff refund issue. If you really want to talk about the details of that, we can. But the basic idea is this. They took something like $165 billion illegally, and when you take people's money illegally, you got to give it back. And you can't whine and make excuses about how it would be a pain to do it. If it's such a big pain, then they shouldn't have taken it in the first place at all.
I feel that requires some applause or something. I don't think we need to go any deeper than that unless people have questions. Obviously, that would be a good subject for questions if people are interested. So back to the litigation. You mentioned the oral argument before the Fifth Circuit. Is that still a pending case?
Yes. The Fifth Circuit held an oral argument en banc, but the en banc decision has not yet issued.
And on which specific issue is that related to invasion?
The Alien Enemies Act.
Okay.
So this is one of a number of Alien Enemies Act cases that is working their way through the federal courts right now. The panel decision ruled 2-1 that the invocation of the Enemies Act is improper and illegal. Most federal courts to have reached that issue have ruled that way, but the case was taken en banc, so we'll see what happens with that. Obviously, similar litigation is going on in several other circuits.
And do you care to do any speculating about the ultimate resolution of these issues by the court system?
So I don't know for sure. Obviously, you know what I think it should be the resolution. I will note that in the JGG emergency docket case last year, the Supreme Court did not resolve the issue of whether there really is an invasion or a predatory incursion and the like, but they did say that the meaning of these terms is judicially reviewable. So I think at the very least, when and if this returns to the Supreme Court is not likely to say the administration gets complete deference and all of this, or there's just totally non-justiciable, but sort of the degree of lesser deference that they might get is still as yet unclear. It is also the case that in the AARP decision, which should not be confused with the American Association of Retired Persons, this is a person whose initials are AARP or something like that. The Supreme Court used the emergency docket to block efforts to deport additional people under the Alien Enemies Act without due process. That also didn't address the ultimate issue of whether there's an invasion or not, but it's some indication that the Supreme Court has at least, majority of it at least, has at least some skepticism about the administration position. But we will see, or we may see, if this issue returns to the Supreme Court, which I'm not certain that it will, but a lot of expert observers think there's at least a good chance that that's going to happen.
Just as a follow-up to that, we were literally just teaching in my common law class looking at Trump versus Hawaii. And one of the things that all the students noted just a half hour ago was the degree to which in that decision, despite evidence of a president behaving abnormally, smoking gun type evidence, the court was so concerned about the operation of the statutory authority in normal times rather than under some sort of aberrant president that they still gave extraordinary deference to judgments even when there was smoking gun evidence of malicious purpose and such. Do we worry about that trend, that tendency, when the courts ultimately interpret this act, the sense that they want to give the normal president, the normal presidency, a lot of deference in this area, and they don't want to rule just because Trump may be going too far?
Yeah, so I do worry about that somewhat, and it is the case that there's a history of judicial decisions like that one, which I think is one of the worst decisions of my lifetime, giving presidents and other officials deference in the immigration area that they would not give in other situations. However, there are notable differences between that case and the Alien Enemies Act litigation. Here, we have arguments based just purely on the words of the statute. What does invasion mean? And in addition, one of the key issues why there was such great deference given in Trump versus Hawaii, again, I think given wrongly, is that it involved non-citizens outside the United States trying to enter. The Alien Enemies Act involves detaining and deporting people who are already in the U.S., including people who are legal migrants or even have the right of permanent residency. Moreover, it would be very difficult to say invasion means one thing in the Enemies Act, but a totally different thing in the Constitution enacted just a few years earlier. So if the court were to rule there must be deference about the meaning of invasion or similar terms in the Alien Enemies Act, the inference would be the same thing is true of the Constitution, which again would mean that it would be the case that the writ of habeas corpus could be suspended at pretty much any time, including for U.S. citizens. States could engage in war without federal authorization at pretty much any time, because anytime there's illegal migration or drug smuggling into a state, which again happens almost all the time since we've had the war on drugs and since we've had significant migration restrictions. So my hope is that the court would note these implications and therefore distinguish Trump versus Hawaii, or better still, I think this is too much to hope for in the near future, they could just overrule Trump versus Hawaii because it's a terrible, awful decision.
So can we talk a little bit about your intellectual journey, if you don't mind, over the last decade or so? And if I do any characterizations of you that you find inaccurate, please correct me. I stand. But you're normally portrayed as a committed libertarian who has taken positions across your career that kind of cross-cut traditional political lines. But your home is at a school committed in large measures towards law and economics methods and originalist methods that are more in tune with the right wing of our judicial and legal system, and you worked with the Cato Institute and other groups like that. So you have a lot of social relationships and intellectual relationships with the right and the right center, and yet you have unabashedly been a critic of many, perhaps most of the policies of the Trump administration in crucial legal questions. And I know that it's one of the interesting things that people have written about you and others, kind of the process of coming to the conclusion that you want to be a full-throated critic of the Trump administration, then you can commit to that, and watching others who you may have agreed with in earlier eras take different positions. Can you just, in general terms, kind of sketch out what the two Trump administrations have been like for you intellectually?
Sure. So Ronald Reagan famously said that he didn't leave the Democratic Party, the Democratic Party left him. So in terms of most of my views on most major issues, I have not changed in any significant way over the last 10 years. What has happened is the political right, if you want to call it that, has moved away from me, just as Reagan once thought that the Democratic Party moved away from him. You can debate whether that was really true, but that's what he thought. So before 2016, I certainly wasn't like a down the line fan of everything the Republican Party was doing or everything the conservatives were doing. I'm libertarian. Many of them are social conservatives, but still, I had various issues in common with them: limiting government spending, limiting federal power for the sake of protecting federalism, stronger property rights, and some other things. Almost all of that has gone by the wayside with the Republican Party in the last 10 years, becoming more like a sort of big government right-wing nationalist party of the sort that we see in Europe with the AfD in Germany, the National Front in France, and others. I was always against those types of movements. I hate nationalism. It's a great evil. I hated it since long before Trump came along. If you look at the history of the last 100 years, the biggest amount of oppression and body count has been racked up by communist regimes, and I hate them. But second biggest is nationalist regimes like the Nazis, fascists, and others, and I hate them too. They're totally inimical not only to libertarianism, but to the liberal tradition more generally, and that's what I have always supported, and I continue to support it under Trump era. This was intellectually easy for me, because I've always thought of myself as a libertarian as distinct from conservatives, and also because I have no particular ambitions to be a judge or an office holder or the like. So, and I never had a deep attachment to either major political party. Things are tougher for people who do have a deep attachment to one party or another, do want to be office holders, and also people who have what might be called sort of negative polarization, that they might not like Trump, but they really hate the left. I have some issues where I obviously differ with the left as well, and I definitely do hate socialism and communism, but ordinary leftists who are not socialists or communists are way, way better than sort of Trumpist nationalist types, and I'm very clear about that.
Why don't I use this as an opportunity, everybody, to remind you all that if you have questions for Professor Somin, to send them in to luminaries at seattleu.edu, luminaries at seattleu.edu. There have been 3 excellent questions submitted so far. We're going to questions in about 9 minutes, and we will have time for 1 or 2 additional questions. So please send them in. Andy.
So we've been pretty efficient in covering the subject of today's conversation, and we brought in tariffs as well, a little bit on your scholarship on migration. But you're so prolific and have so many interesting things that I'd love to give you an opportunity to highlight some of your other major works and intellectual commitments. I can think of a few, but I think I'll just start with an open question and tell the students about some more areas in which you've written books or articles that you're particularly proud of.
Sure. So the book that I like the best out of my 6 or 7 books, depending on how you count, is Free to Move, which you mentioned earlier, which makes the case for broadening opportunities for people to vote with their feet, both internationally and within countries. And I argue there also that often that's a better and more effective mode of political choice than voting at the ballot box, which has the problem of that your chance of actually affecting the outcome when you vote at the ballot box is infinitesimally small. Whereas when you vote with your feet, you have a real chance, if you're allowed to do so, of determining what sorts of government policies you want to live under. My book that is probably the most influential of my books, even though it's not my favorite one, is Democracy and Political Ignorance, which is all about a deep structural problem of democracy where most voters have very little incentive to become knowledgeable about politics and issues because the chance that your vote will make a difference, the outcome of an election, is infinitesimally small, about 1 in 60 million in a presidential election in the US. Even in a state or local election, it's still 1 chance in many thousands or 1 chance in several million. This leads to what economists call rational ignorance. If your only reason to be a well-informed voter is to cast a better ballot or better informed ballot at the ballot box, that's not much of an incentive at all. And so you find that most people know very little about politics. They don't even know very basic things. There is a minority whom I call the political fans who learn about politics not necessarily because they feel like they have a high chance of influencing outcomes, but because they like it, they enjoy cheering on their favorite political team, just like people enjoy cheering on their favorite sports team, not because they can influence the outcome of games, but because they like supporting their team and they like hating the other team and the like. And political fans, they know more about political issues than most other voters do, but they tend to be very biased in their evaluation of information, and that's also a problem. And in that book, I trace out the implications of political ignorance, and I argue that there are several possible ways to mitigate the problem, but the best one is to empower people to vote with their feet, like in my later book, Free to Move, where they have much better incentives to make good decisions when they vote at the ballot box. I also go through their various arguments that used to be big but are less influential now, which say we don't need to worry about political ignorance. Even ignorant voters can make really good decisions. When I first started writing about political ignorance now more than 25 years ago, that was the argument that I was most often faced with. But my side of that issue has been made great again by recent events the last 10 years. And therefore, today, more of the debate is not about whether political ignorance is a problem. Not everyone acknowledges that it is, but most experts do, but rather about sort of what we should do about it. The other big area that I've written a lot about is property rights. My book, The Grasping Hand, is all about the Kelo decision, which some of you may have read in property class, and I explain why that decision and other similar decisions are wrong, and the Supreme Court should protect property rights more. More recently, I've written a lot about exclusionary zoning and its connection to the Takings Clause and property rights, where that actually overlaps 2 of my interests, one in property rights, but also in the area of mobility, in that the biggest obstacle to domestic mobility in the United States, the biggest obstacle to people moving to opportunity is exclusionary zoning. About 75% of the residential land in the US is zoned for single-family homes only. That prices out a lot of people, particularly lower middle class, the working class, and also disproportionately minorities. So About a year and a half ago, I published an article in the Texas Law Review with Josh Braver of the University of Wisconsin, which is called The Constitutional Case Against Exclusionary Zoning, where we go into this issue in much more depth, and we have a follow-up article planned as well.
So, as someone who has this rich intellectual history and a portfolio of scholarship that is thematically and connected and methodologically connected, but kind of cuts across the law school curriculum, wildly curious which classes you teach.
Sure. That's not a hard question. I hope. I teach constitutional law, both one, which in our school is the structural constitution, and two, which is the 14th Amendment. I teach property, as you can probably guess. And at times I teach legislation when the school asks me to, and I also teach a seminar on federalism. Next year, I'm hopeful that a colleague and I will be teaching a seminar on emergency powers and the judicial review thereof.
Wonderful. I think it's a good time to transition to Tony and the questions from the audience.
Yes, and we have really excellent questions from our audience. Let me ask this one first from Professor Omari. This question: you suggested Biden's student loan plan was an abuse of emergency powers. Do you agree with the court's reasoning, specifically in its relying on the major questions doctrine in that case? What's your view of the doctrine overall?
Sure. So I do agree with their use of the major questions doctrine. It was very obviously a major question, $430 billion in loan forgiveness. In fact, it was the single biggest major question that had come before the Supreme Court until we had the tariff case, which is even like 4 or 5 times more money than that. But $430 billion, I think, is a pretty big amount of money, even if it's not quite as much as the truly gargantuan amount at stake in the tariff case. And also, at the very least, it was ambiguous whether that statute authorized mass loan forgiveness. I don't fully agree with some aspects of the court's textual analysis. If it were up to me, I would have based it not so much on a distinction between modification of loans and forgiveness, and more on the fact that there was no proof for the vast majority of the people for whom loans were going to be forgiven, that they were impaired in their ability to repay by the COVID national emergency. If you look at sort of who became unemployed or who became seriously ill, it was actually disproportionately not college graduates, but non-college graduate workers who were more likely to be exposed to the pandemic and the like. So while I think maybe that statute, which allowed loan forgiveness in the event of an emergency when the national emergency impaired people in their ability to repay, might have allowed a much more narrowly targeted plan targeted towards people who had suffered prolonged unemployment or got seriously ill or something like that. What we were talking about is a plan for tens of millions of people, the overwhelming majority of whom were not in any way meaningfully impaired by the COVID pandemic and their ability to repay. And so this was an abuse of emergency powers to achieve a policy objective that the president at the time, Biden, could not get Congress to do. Congress has been discussing loan forgiveness for years. And even when the Democrats controlled both houses in the first 2 years of Biden, they couldn't get a majority to do it. But that doesn't mean the president can just do it on his own. As for the major questions doctrine generally, I think it is a good doctrine. If you look at the tariff case, there's a debate between Justice Gorsuch and Justice Barrett, where they debate whether the major questions doctrine is justified as a sort of structural provision for limiting unconstitutional delegations, which is what Gorsuch thinks, or if it's justified sort of on textual linguistic grounds, on the grounds that when you claim a big, massive delegation of power, we would expect it to be clear than when you claim a narrow one. That's Barrett's view, symbolized by her famous babysitter analogy, which we can talk about if you really want. I actually think they're both right. I think there is more than one justification for this doctrine, and both justifications are correct, though there might be unusual individual cases where one is right, but the other one doesn't apply for some reason. So I think they're needlessly attacking each other, and they should just recognize that they both have a point, but they both devoted many, many pages to one attacking the other, and the tariff in their concurring opinions in the tariff case. So I don't look for them to sort of kiss and make up over this issue anytime soon.
So that was Professor Omari over there. Why don't you raise your hand, Professor Omari? So We can see you. And then our great 1L, Sophie Walker, has asked another question. Sophie, raise your hand so that we can see you. Okay, there you are. And Sophie asks, how do you think constitutional law is going to change and be affected from SCOTUS's decisions that have been in favor of Trump's policies? And how do you think we should address and move away from the extreme partisanship that has been occurring of late?
Yeah. So the second question is sort of a big, profound one that I don't know that I have an easy answer to. Certainly, I don't have an answer that can quickly be implemented and solve this problem. I do think, and I've written about this, that if we decentralize power in various ways, allow people to make more decisions by voting with their feet, have less power concentrated in the federal government generally and in the president specifically, that our politics would be at least somewhat less poisonous, because part of the reason why it's as bad as it is now is because people are really afraid of what happens when the executive branch and maybe the federal government generally is controlled by the opposing party. If the federal government and the executive had less power, I'm not saying there would be no danger, but the danger would be less and the fear would be less as well. As for the future impact of the decisions, that Trump has prevailed on over the last year or two, obviously, as Yogi Berra said, the predictions are difficult, particularly about the future. So for some of these issues, it's hard to know for sure. We don't have proper historical perspective on them. Also, some of them are emergency docket decisions, which don't have as much in the way of reasoning, obviously, as other decisions do. So I do think some of them are likely to be consequential. Like if it is the case that in the current Trump versus Swatter case, if, as most people expect, the Supreme Court rules that the president has broad removal power over all sorts of federal agency leaders, even those that Congress tried to insulate, I think that will increase the power of the presidency over time. I think there may be other cases which have significant long-term impact as well, but it's not always easy at this point to fully predict it. I do think also some of the decisions going against Trump may also have a long-term impact, including maybe the tariff decision, maybe the Alien Enemies Act decision, and others. But for those two, to fully understand, we may need sort of more and better historical perspective than we currently have.
Why don't we go back to our faculty colleagues for a question? So question from Professor and Associate Dean Russ Powell. Russ, raise your hand. There you are. Can you explain the shift from concern regarding illegal immigration to the rather shocking attacks on legal immigration processes over the past year, i.e. asylum, or e.g. asylum, refugee processing, parole, TPS, immediate family and employment status, etc.? This seems inconsistent with the conservative approach to these issues for decades.
Yeah, so I would say a couple of things. One is a wide range of arguments used to attack illegal migration can also be used to attack legal migration. These people have the wrong kind of culture. They're spreading bad values. They're increasing crime. They're taking jobs from Americans and so on. And ultimately, there is a common worldview linking these attacks that has several elements which apply to both legal and illegal migration. One is a sort of zero-sum view of the world, which exists among some people on the left as well. But on the right, it manifests itself in the sense that Americans can only gain if foreigners lose and vice versa. So if immigrants are taking jobs, that's fewer jobs for Americans. You see this with trade as well, that Trump says, when we have a trade deficit, we're losers and those other countries are winners, even though what's actually happening is we're buying goods that we value more than the money that we spend on them. And similarly, immigration is also not a zero-sum game. But if you believe that it is a zero-sum game, then that applies to legal immigrants no less than illegal ones. And in addition, I mentioned nationalism before. A nationalist worldview says that the main purpose of government is to promote the interest of a particular ethnic or religious or racial group, which is the dominant group in the country or is supposed to be. And roughly speaking, I'm oversimplifying somewhat, but for American nationalist types, it tends to be native-born white Christians. That is who they think is the principal group that the government should be aiding and supporting. And if you take that view, then people who don't fall into that category, whether they're legal or illegal, they're still at the very least suspect. And then finally, if your only objection to illegal migration is just that it's illegal, then there's an obvious, easy solution, which is just to legalize it. So as I've written in some of my works, the trope which says, well, I'm for legal immigration, but against the illegal kind, that evades in some ways the real issue, which is like, why should it be illegal? Like when we talk about, say, marijuana legalization, if somebody says, well, I'm for legal marijuana, but not the illegal kind, it's very obvious that they're evading the issue because the whole question is, whether and to what extent this should be legal. And similarly, there's a historical analogy between migration and racial segregation. In both cases, people are restricted where they're allowed to live based on arbitrary circumstances of ancestry and place of birth. If somebody in 1950 were to say, I'm for legal integration of the races, but I'm against the illegal kind, then the obvious question is like, where, if anywhere, is it justified in being illegal? And are you opposed to just abolishing the segregation laws? And when you get the answer to that question, for segregationists, it would not be an answer of like, it should be illegal just because it's illegal. They would give reasons why they think racial integration is bad. And the same thing here. If you ask this question to restrictionists of like sort of why should it be illegal, most of them will not say it should be illegal just because it's illegal. They will give you a list of reasons. And most of those reasons do have application to large categories of legal migrants as well as the illegal kind.
So we have 4 minutes left, and I'm going to present you with two final questions from our audience, Ilya. Let's go back to our students. So Christian Wiswell, raise your hand. Christian? There's Christian. Here's a question for you, Ilya. The Constitution treats invasion as a nation state sending soldiers across borders, and that's a perfectly plausible definition. Migration into the United States is clearly not like that, but it isn't like there aren't analogs from the time. What do we know about how the founders felt about Native Americans coming from outside American territory into the United States? Was this treated like other kinds of settlement from Europe, say, or in some other way?
So it's an interesting question. I would note first that my argument does not require that an invasion must be by a nation state. I argue it has to be a military attack, but it could potentially be by an insurgent group or a terrorist group or the like. So I think Hamas's attack on Israel in 2023 was an invasion, even though you could argue Hamas was not a recognized government. They were sort of de facto government of Gaza, but they were not internationally recognized. As for Native Americans, you could probably have a whole entire separate event on the issue of Native Americans and their status in our constitutional law and other law. For now, I'd merely say that I think it is the case that a Native American tribe which launched a military attack could be conceived of as engaging in invasion. I think that's very possible. But mere migration by Native Americans was not something that was considered to be a form of invasion. There obviously were whites who were prejudiced in various ways against Native Americans and against some other non-whites as well. And there's a long history of legal debate, another debate about whether Native American nations qualify as sovereigns in the same way as European nations or the U.S. were thought of as sovereigns, or whether there's something different. But the mere fact of migration by individual Native Americans was not something that was seen as an invasion, and in fact occurred all the time, both in the founding era. So there is a broader, more difficult issue about what was exactly the legal status of Native American nations, on which a huge amount of ink has been spilled by law professors much more qualified than me to talk about it. But for the purposes of an invasion, I think it's plausible to say that a Native American tribe could launch an invasion, and such things were significant concern for the founders. But mere migration or smuggling of illegal goods, which certainly Native Americans engaged in, just like white people engaged in during the time of the founding, that was not an invasion.
Mm-hmm. And then finally, back to a faculty colleague, Paula Enguidanos, there she is, has this wonderful question. How do you keep yourself informed? What do you read? What is a question to end on?
I guess it depends on what it is that I'm trying to be informed about. If I'm just keeping up with issues I'm already familiar that I read about, like migration or property rights or something else, then I sort of know which publications write about it regularly, which people are the recognized experts and the like, and so I can rely on that to point me to source of information. With issues that I know less about, It depends on the nature of the issue, and I try to reference some of my own work on information shortcuts and the like, and try to find reputable authorities on the question, but exactly how to find them and where, that will vary a lot from issue to issue. I will note that when it comes to use of information shortcuts, we do better when we have better incentives, like when we know that our decision is likely to make a difference. Like, I know nothing about cars, but when I went out and bought a car, I recognized that I know nothing. I looked at reputable sources. I convinced my brother to go with me to help me buy the car because he knows a lot more about cars than I do, and so forth. And I certainly won't say that I engaged in perfect decision making. I didn't make any mistakes, but I did a pretty good job of coping with my ignorance. Whereas in areas where we have bad incentives, like with political information, it's not just that people start out ignorant, but that they do a poor job of coping with it because the incentives to do so are weak.
What an outstanding conversation. Thank you so much, Professor Somin, Professor Siegel, and thank you, all of you, for your excellent questions and for your presence. Thank you, everybody. See you next time.
Thank you.